Hello. Hi. Hello. Happy Monday. Hello, hello, hello. Can you see me and hear me okay? I know somebody said I was having mic issues my last live, so I don't know. Hello, welcome. Hi. It's good to see everyone. I hope you're doing well. Let's see who's here. I saw Tipsy Gypsy in here. I see Abuelita's Journey. Robert, number 7. Hello. Hello, hello, hello. Loud and clear. I hope you guys are doing well. Let me check something really quick on my computer. We're going to be covering Courtney Clenney today. If you're not familiar with the Courtney Clenney case, she unalived her boyfriend by stabbing him in April of 2022. She is the OnlyFans model. She has been incarcerated since September of 2022. Basically fighting the whole thing. She's claiming it was self-defense. She stabbed her boyfriend, Christian Obumseli. If you're not familiar with the case, I do have a whole playlist where we do deep dive interrogation, body cam footage, all details of the case. So make sure you go watch that. I feel like this case has been a little bit quiet just because they've been fighting so much on the back end. So for example, her parents got charged with accessing Christian Obumseli's laptop. That ended up being dropped. In August of last year of 2024, I covered a document where the DA, Khalil Quinnen, they were looking to remove him because he accessed information that was basically not his business. And so they ended up dropping those charges against the parents. And now her defense team is fighting that, they want a motion to dismiss the whole district attorney's office because it's basically tainted. So they're basically saying that having ASA Khalil Quinnen removed isn't sufficient enough and it taints her case, and it doesn't give her the fair opportunity for basically a fair case, fair trial. So they want to remove the whole district attorney. So I feel like this is an important motion. There's a court date on the 22nd, which I'm hoping Court TV will be there so we can watch it. Her documents, you have to request them, so they're not accessible right off the bat, which is a little complicated sometimes. But I'm hoping we can stream that when it comes out on the 22nd, I believe is the next hearing. So what will happen with the Courtney Clenney case? Is she going to get out on bail? That's kind of what she wants. Are they going to dismiss the whole case because it's tainted? Probably not, because Christian Obumseli deserves justice. She's claiming it was self-defense when she stabbed him, and it was pretty brutal. If you go back on my Courtney Clenney playlist and watch the body cam footage, it's pretty brutal. So we're going to read this new motion. It was just dropped on the 30th. So I didn't see it until a few days later on the docket. So we're going to read through it. We read documents here all the time. Thank you for being here. I appreciate it. After this live, we'll continue with the Karen Reed case that I am following. So hope you guys can make it, and thank you for being here. Hey, Five Cats. Good to see you. Let me pull up the document and let's get started. I'm very interested in this case, and I know it's moving a little bit slower just because there's things that have come up, and now the states, now they're looking shady, like they were accessing information that they weren't supposed to be accessing. And so it gives Courtney kind of like a one-up, if you may, but they're seeking to disqualify the whole state attorney's office, which is crazy. And my whole thing is, they didn't need to do any of this. I think they have a good solid case on Courtney Clenney. I think that the body cam footage, the evidence all proves a good case. So, all of these things, like looking at information that isn't pertain to them, like why would they do that? They're trying to prosecute her. So let's get started. Like I said, filed 430, amended motion to disqualify the Miami-Dade County State's Attorney Office, State of Florida versus Courtney Clenney. And it's since amended because, like I said, in August of 2024, they filed a motion to disqualify Khalil Quinnan, the former ASA, he has since stepped down from the position, which speaks volumes as well, if you weren't aware. And now it's Sean Abuhoff, who was the assistant ASA, and now he's moved up into the position. So there's been quite a change of things. And it's amended because in August, they were they filed a motion to dismiss him then. And then in the midst of that, they found other information out, which we're going to read about it here, that kind of made him step down. So we're going to get started. Comes now to defendant Courtney Clenney. If you're not super familiar on this case, or it's been a while, we're going to read a little bit of the first few paragraphs is like a history of what's been going on. So, and the details of the case. So Courtney Clenney was charged by information with second-degree murder and was arrested on August 4th, 2022 in connection with the death of Christian Obumseli, which occurred on April 3rd, 2022. She was dating Christian Obumseli for about 2.5 years, and they had a very toxic, violent relationship. You can see that in the previous videos that I have. We watched the body cam footage. There's a video of her in the elevator. There's a video of her out in the streets riding the bikes. There's a lot of videos of where she's putting hands on him. We don't really see him putting hands on her. She's claiming it was self-defense, that she threw in a knife and stabbed him in the chest due to self-defense. Or was it just cold-blooded murder and she was just being crazy and toxic? She's an OnlyFans model, so that plays a huge role into it. They were living in a really nice penthouse or whatever when the stabbing occurred. And, people knew what was going on. They were going to be evicted for how bad they were fighting. So there's a lot of factors, I think, that play into this case. It's one of my favorites. We're going to be covering it later this week as well. I'm back to my normal scheduling, hopefully. So for now, we're going to be doing Karen Read on Melly After Dark and then catching up in the midst of all the other true crime. So Attorney Frank Prieto was promptly retained by the Clenney family to represent Courtney Clenney, as well as to protect the interests of Kim and Deborah Clenney. Those are her parents. This oral agreement was later formalized in a written retainer agreement dated September 5th, 2022, covering attorneys Frank Prieto, Sabrina Puglisi, and Diane Karamas. The state of Florida is represented by Assistant State Attorney, the ASA's Sean Abuhoff and Kathleen Hogg, and previously included ASA Khalil Quinnan. He's the one who has since stepped down. On November 3rd, 2023, the City of Miami Police Department obtained and executed a warrant for the iCloud accounts of Courtney Clenney's parents, Kim and Deborah Clenney. The warrant was almost identical to one initially issued in March of 2023, which had since gone stale. The warrant application, excessive in both scope and time, saw access to the entire iCloud accounts of the parents from November 2020 to present, which at the time was through March 2023. It's a long time. According to the warrant application, law enforcement sought information from Kim and Deborah's accounts because of a message exchange with Subject 1, known photographs taken of Subject 1 by Subject 3, and the commingling of financial accounts by Subject 2. See affidavit in support of warrant. 7. Despite the application's description of specific information sought within a limited time frame, law enforcement requested access to the entire iCloud accounts. This included data from 17 months prior to the April 3rd, 2022 incident and data from 7 months after Courtney Clenney's incarceration, which she did not have access to a cellular phone to communicate with her parents. So they went back from when she stabbed Christian, they went back 17 months prior. That's like a year and a half. Prior to her stabbing. Yeah. So, and then 7 months. Why were they like going through her cloud if she was in jail for 7 months? That is really interesting. Really very interesting. Hey, S-Dubs, good to see you. Hey, Domestic. Sorry if I missed you earlier, I was reading. So as a consequence of the information obtained from this overly broad warrant, law enforcement accessed attorney-client and work product privilege communications between attorneys Frank Prieto and Sabrina Puglisi and their clients/parents, Kim and Deborah Clenney, which occurred after Courtney Clenney's incarceration. The first privileged communication at issue took place in a group text titled, quote-unquote, Team Courtney, involving the attorneys, their paralegal investor, and Kim and Deborah Clenney. At no point did anyone from the state attorney's office contact counsel to ascertain whether Kim and Deborah Clenney were represented by counsel, despite knowing that counsel represented their daughter, nor did they reach out to Mr. and Miss Clenney, who were listed as state witnesses, to inquire about the representation in order to filter their names from any subsequent search. ASA Quinnen conducted a search of the iCloud accounts and discovered the quote-unquote Team Courtney communications. The content of the Team Courtney chat involved discussions regarding all matters related to Courtney Clenney's case, including communication regarding case investigation, witness testimony, defense witnesses, expert witnesses, financial obligations, defense theories, counsel thoughts and impressions, and opinions on the case. These were communications that the parties believed to be private and privileged. During the unlawful review of privileged communications by ASA Quinnen, he uncovered discussions about a laptop in the possession of the Clenney family and the defense's investigation into its potential evidentiary value. I mentioned that at the beginning, how that case was dropped against, that charge was dropped against the parents because of this. So, again, it's just giving ammo to Courtney Clenney's defense. In my opinion, according to ASA Quinnen, he denies reviewing any discussions in the Team Courtney chat beyond those pertaining to the laptop. He alleges that he limited his review to only a few messages immediately preceding and following the reference to a laptop. The deposition of Khalil Quinnen. Okay, so we're going to cover that here too. We're going to get into it. I want to read that really, really bad because he has since stepped down from the position. So, it's messy. It's messy. When there's a deposition, generally, that it means something is going on, right? There's something messy going on. And those are some of my favorite documents to read. Oh, Estebs, thanks for renewing your membership. Thank you. I appreciate that. Hello, Jason. Good to see you. Let's continue. This is kind of wild. In an unrelated written communication, Quinnen asserts that upon review of the messages pertaining to the laptop, he immediately ceased review and went to obtain counsel from his supervisor, co-counsel, state attorney's office, appellate counsel, and defense attorneys. According to ASA Quinnen, everyone he consulted with believed the communication was not privileged. As a result, he continued his review of the iCloud and referred to the matter to law enforcement. The state attorney's office, relying solely on the privileged communications and without any additional evidence, filed an information in A, B, C, charging Courtney, Kim, and Deborah Clenney with unauthorized access to the laptop. When drafting the arrest warrant for the defendants, Kim and Deborah Clenney, ASA Quinnen approved the inclusions of attorneys Frank Prieto and Sabrina Puglisi as uncharged individuals who allegedly committed the crime alongside the charged individuals. It was only later that the state attorney's office conceded that the undersigned counsels had not acted improperly. However, this concession came only after public accusations had already been made. After the arrest of Ms. Clenney's parents, it became clear to the defense that the state of Florida had viewed attorney-client and attorney-work product communications. Once the extent of this breach into the defense camp was learned, counsel sent correspondence to the state demanding the immediate return of the privileged materials. This is wild. And her parents did get arrested for this, which is crazy. And then the charges were dropped because they messed up. That's crazy. And like I said at the beginning, they have a good case. They have a solid case against Courtney Clenney. So I'm not sure what they're doing. I'm not sure. Hey, Thomas. Good to see you. Thank you for being here. We're covering the new moment. I was reading the chat. The new motion for Courtney Clenney case, if you're not familiar. But thanks for being here, Thomas. Adding to the state's misconduct, they failed to respond to the request, and there's no evidence that they deleted the information. Further, after no response was received, counsel for Ms. Clenney sent a second letter on February 28, 2023, that also garnered no response from the state. On June 26, 2024, the court entered an order granting a motion to exclude and or suppress filed in case numbers F, A, B, and C. The order found that the communications reviewed by the ASAs and law enforcement were privileged as attorney-client and/or work product communications. On August 20th, 2024, the defense filed a motion to disqualify the state attorney's office based upon the review of the Team Courtney chat. Subsequent to the filing of the motion, the defense was made aware of an additional and even more egregious breach of privilege by Assistant State Attorney Khalil Quinnen. After a public records request made by a third-party defense attorney, it was revealed that ASA Quinnen had also accessed another privileged communications sent from attorney Sabrina Puglisi to Courtney Clenney's parents. The communication included an attachment titled Courtney Checklist of Things to Do, Privilege Doc. Upon opening the communication, the first page of the document clearly displayed the fields from, sent, and to subject and attachments, with from being the attorney for Courtney Clenney and the attachment specifically named as Courtney Clenney Checklist of Things to Do, Privilege Doc. Despite these obvious indications that the communication was privileged, ASA Quinnen forwarded the email along with the privilege attachment to law enforcement on December 29th, 2023 at 6:01 p.m. ASA Quinnen saved the email and attached an attachment under the title Has Email, PDF. The second page of the attachment contained detailed bullet points outlining the defense's trial strategy. The procedure in the state's attorney's office when a Chapter 119 public records request is made is to provide a copy of the requested information to the assigned assistant state attorney. In this case, ASA Quinnen volunteered the privileged document only after he was made aware that the document was provided in a Chapter 119 return. ASA Quinnen alleges that he did not even remember seeing the email with the attachment because it was so inconsequential. While ASA Quinnen attempted to excuse his conduct by citing personal stressors, including late night work, the end of the year, his wife's pregnancy, and construction, none of these circumstances justify the review and dissemination of a clearly privileged communication, particularly one so plainly marked as such. So, okay, I kind of think that's lame that he said that was the reasons for him being like tired or whatever. After learning of ASA Quinnen's undisclosed further review of privileged email communications, the defense sent a third letter demanding the return of attorney-client and attorney-work product communications. All correspondence requesting the return of what the court deemed to be clearly privileged material sent to all state counsels, ASA Quinnen, ASA Kathleen Hogue, and ASA Sean Abuhaf, was met with silence from the state of Florida. In prior pleadings and during court hearings, ASA Khalil Quinnen repeatedly represented to the court and to the defense counsel that he seized all review of the Team Courtney chat immediately after discovering the text communication referencing the laptop. His statements conveyed that he did not review any further materials after encountering the laptop reference. However, after the defense independently uncovered through a third-party public records request that ASA Quinnen had in fact reviewed and disseminated an additional privileged document, the quote-unquote Courtney checklist of things to do, it became clear that his prior representations were misleading. At his deposition, ASA Quinnen attempted to reframe his prior statements, asserting his claim that his review immediately ceased should be understood in a vacuum, meaning solely limited to his review of the Team Courtney chat and not to his broader review of other iCloud materials after discussion with other members of his team and counsel at the state attorney's office. Despite becoming aware of the fact that he had continued reviewing privileged materials beyond the Team Courtney chat, ASA Quinnen failed to proactively inform the court or defense counsel to correct the record. Had the defense not independently discovered the additional review through public records, ASA Quinnen's violation would have remained concealed. It is only after the defense uncovered this misconduct that ASA Quinnen sought to provide an after-the-fact explanation for his actions. That's wild. They're basically saying, hey, and you didn't even admit to it. Like, if it was an accident, you would have at least came clean. Hey, Kat Randall, good to see you. Hey, Oscar, good to see you. Thanks for being here. This is intense. The defense filed a motion to determine the confidentiality of records, arguing that the attachment detailing the trial strategy was privileged opinion work product. In an oral pronouncement, the court agreed. The state attorney's office was snooping around in these emails. That's wild. she's probably going to get bail. She's already been locked up for 2.5 years, and this is the second huge mistake that they make. And she's probably going to get bail. What do you guys think? Did she do it in self-defense? Did she stab Christian Obumseli in self-defense? Or was she just a toxic, wealthy girl who had mental health issues when she was beating up on her boyfriend? And do you think she should get bail? And do you think that the state attorney's office should all be disqualified in its entirety? That's a lot. It's going to take a lot for a new office to step into the case now. It's going to take a long time for them to get familiar with the case, and it's going to either they're going to let her out on bail, or she's going to, be locked up for some time while they learn the case. Additionally, despite the apparent privileged nature of the communication and the later confirmation by this court that the document constituted quintessential opinion work product in her order granting, in part, defendant's motion to compel the deposition of ASA Khalil Quinnen, ASL Quinnen continued to maintain that the materials he reviewed were not privileged. He testified that he did not seek guidance as to whether this email was privileged from his supervisor, co-counsel, or any other attorney at his office. Following the defense's discovery of this breach, ASA Quinnen did not immediately withdraw from the case. Instead, he engaged in extended litigation, arguing that the communications were not privileged. Only after significant motion practice and this court's rulings did ASA Quinnen finally withdraw. Additionally, throughout the litigation, each motion was signed or adopted by ASA Abuhoff and ASA Hogg, showing their joint participation in the state's position. My apologies if I'm saying her name wrong. Compounding the prejudice, the defense later learned that approximately 60 individuals within the state attorney's office accessed Courtney's case file. 60. Oh my gosh. That's wild. To replace that many people. I mean, are they just going to have to dismiss the case, or are they going to give her a plea deal? Oh, this is intense. Although ASA Quinnen testified that the privileged communications he reviewed were maintained on external drives and were not uploaded to the V-case system, without a full investigation into everyone who accessed the case file, it is impossible to determine the full extent of privileged information exposure. Despite the number of people with access, no disclosure logs or filters were produced to confirm the scope of access. Investigation into these individuals would require extensive delays, further prejudicing Ms. Clenney's desire to proceed to trial. See, they're already saying this is going to make it longer for her. This isn't fair, quote unquote, fair to her. On April 30th, 2025, while in open court and under oath, Assistant State Attorneys Sean Abuhoff and Kathleen Hogue each affirmatively stated that they did not personally review any of the privileged communications at issue. At no time during the review of the iCloud material did law enforcement or the state attorney's office establish a filter to prevent the review of attorney-client or work product privileged communications with respect to the iClouds of Kim and Deborah Clenney. Consequently, privileged communications were reviewed by both law enforcement and the state attorney's office. The improper and unethical actions of the prosecutors assigned in the state attorney's office have led to a 1-year delay in Ms. Clenney's case. This delay has significantly prejudiced Ms. Clenney's right to a speedy trial and prepare her defense uninhibited by government intrusion into confidential strategy. Oh. Hey, Adrian. It's getting out of... I never thought it was self-defense, in my opinion, says Tipsy. I don't know. I mean, I don't think it's self-defense, but this document is really throwing me off. This is kind of wild. I don't think it was self-defense either. And it sucks that she might get that because of all of these mess-ups. It is a fundamental, so this is a legal argument. It is a fundamental concept of constitutional jurisprudence that a criminal defendant is entitled to a fair and impartial trial, irrespective of the crimes charged. A fair trial cannot exist in the absence of fair and ethical prosecutors, those charged with the unique power and extraordinary responsibility to assure that justice is served. noting that a prosecutor's interest in a criminal prosecution is not that it shall win a case, but that justice shall be done. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. I'm not going to read that part of the Supreme Court. We're going to just skip past that. Here, the Office of the State Attorney for the 11th Judicial Circuit in and for Miami-Dade County violated their fundamental duties by reviewing attorney-client and work product privileged communications. These communications gave them access to defense trial strategy. In the face of such violations, the confidence and trust that Courtney Clenney will be prosecuted fairly by the state attorney's office is significantly undermined, if not extinguished. Substantial misconduct and irreparable taint. Substantial misconduct has been conclusively established. Prosecutors accessed defense attorney-client and work product privileged communications, including a document later ruled to be quintessential opinion work product by this court. The iCloud warrant obtained by law enforcement with the knowledge and approval of the state attorney's office sought information far beyond permissible bounds. Communications between Courtney Clenney's parents and her defense team occurring after her incarceration were improperly accessed. As this court correctly observed, quote unquote, the prosecutors should have understood the communications to be work product as soon as they saw the communication was from Courtney Clenney's attorneys and was related to her murder case. The misconduct was compounded by the later discovery that ASA Khalil Quinnen had continued to review the iCloud materials and discovered a privileged document titled Courtney Checklist of Things to Do. Despite the document's clear labeling and contents, ASA Quinton did not inform his supervisors, nor did he seek clarification about privilege. Instead, he forwarded the document to law enforcement, made excuses as to understanding its true nature, and continued to maintain that it was not privileged, even after this court's ruling. ASA Abuhoff and ASA Hogue later adopted and ratified this conduct through signed motions and court arguments. ASA Hogue, as Quinnen's supervisor, bears responsibility for this failure to supervise and ratification of misconduct. Again, Quinnen has since stepped down from the position. Hey, KX, good to see you. Moreover, the defense later learned that nearly 60 individuals within the state attorney's office accessed Courtney Clenney's files in the V-case system. Why so many individuals access this case is unknown, as only 3 prosecutors have ever been assigned and appeared in court on the matter. Although ASA Quinnen testified that the privileged materials were not in V-case, without investigating all 60 individuals, the defense cannot determine whether additional privileged information was reviewed. Requiring such an investigation would cause unreasonable delay that has already occurred solely due to the state's own misconduct. Despite the privileged nature of the material he accessed, ASA Quinnen did not acknowledge the privilege. Instead, the prosecutors continued to argue that the communications were not privileged, even after reviewing materials that plainly laid out the defense trial strategy. Although the state did raise a waiver argument, it was not based on case law governing opinion work product. The privileged document, entitled Courtney Checklist of Things to Do, plainly contained detailed trial strategy and defense witness plans and mental impressions of counsel. It is hard to imagine that any experienced attorney, upon reviewing such a document, could believe it was not protected opinion work product. Florida law is clear that the waiver of privilege occurs only where the disclosing party should have reasonably foreseen the materials would fall into the hands of opposing counsel. The state did not and could not argue that an email communication from defense counsel to Courtney Clenney's parents discussing trial strategy met this standard. As the court found, there was no reason why defense counsel should have reasonably anticipated that such a privileged communication would be accessed by the prosecution. Subpoenas for depositions had already been issued, and the depositions of Arthur Cupp and Bobby Brenton had already occurred before the defense became aware of the extent of the breach. Therefore, prosecutors who had been exposed to privileged defense trial strategy participated in critical witness questioning while tainted by improperly obtained information. Although ASA Khalil Quinnen appears to have been the principal violator of privilege, as he admitted to searching the iCloud data without implementing any filter protocols, and but for his actions, the privileged information would not have been accessed. Responsibility does not end with him. All three prosecutors, Quinnen, Sean Abuhaf, and Kathleen Hogue, discussed the quote-unquote Team Courtney chat. They want all of them out. They want all new prosecutors. This is wild, and they might have to give it to them. This is privileged communication. Hey, Debbie, good to see you. Hey, Dustin. Was it about right. Alsane, where have you been? I'm coming for you. This is crazy. We're covering the new motion to dismiss the whole state attorney's office in the Courtney Clenney case. Why do I have a feeling she's going to get bail and or she's going to get a cushy little plea deal, because this is the second time they mess up on this case. I'm shook. The prosecutors all are going to have to be replaced. While ASA's Abuhaf and Haag have now stated under oath that they did not personally review any privileged communication, this alone does not insulate them from disqualification. Although it appears that ASA Quinnen continued to search the iCloud returns, located the Courtney checklist of things to do document, trial strategy document, and did not inform his supervisor, co-counsel, or any other attorney about the privileged nature of the document, it is difficult to accept that ASA's Abuhaf and Hogue, I don't know how to say her name, sorry, argued in court that the checklist was not work product privileged without having seen it or discussed it with Quinnen. Their continued participation in this matter and formal endorsement of legal positions derived from the privileged material presents an appearance of impropriety that cannot be overlooked. Florida law does not require actual misconduct by each individual prosecutor to warrant disqualification. The failure to intervene, supervise, or filter and the ratification of tainted conduct are sufficient to create an intolerable risk of prejudice and erode public confidence in the fairness of the proceedings. Even with no knowledge of the second breach, their endorsement of that legal position raises even greater concern. What is of paramount importance is that Courtney Clenney receives a fair and impartial trial. Yes, we're having some buzz tonight for Karen Reed. I'm behind. Don't come for me. We're getting caught up this week. Don't you worry. Florida law holds, okay, this is part 2. Sorry. Actual prejudice and necessity of disqualification. Florida law holds that disqualification of a prosecutor requires a showing of substantial misconduct or actual prejudice. Actual prejudice requires, quote unquote, something more than the mere appearance of impropriety. However, on a case-by-case basis, specific or actual prejudice will not be required where the appearance of impropriety is strong. Disqualification is therefore a prophylactic remedy for likely future prejudice, not a punishment for past wrongdoing. Although trial has not yet occurred, the irreparable taint created by the prosecution's exposure to detailed defense trial strategy and mental impressions establishes actual prejudice now. Prosecutors who have accessed privileged materials participated in the depositions of defense witnesses, including Arthur Cupp and Bobby Branton, before the full extent of breach was revealed. The risk that privileged information will consciously or unconsciously influence trial preparation, strategy decisions, or witness examinations is not speculative, it is inherent. Florida law does not require the defense to show that the privileged information will be used at trial, only that the exposure itself creates a real risk of unfairness that the defendant otherwise would not bear. The core purpose of disqualification is prophylactic to protect the adversarial system from contamination before irreversible damage occurs. Moreover, the prosecutors involved have misled court and counsel about the extent of the review of privileged materials and have failed to acknowledge their misconduct, continuing to assert that no privilege attached to plainly privileged materials. This information and refusal to recognize wrongdoing amplifies the risk of continued prejudice and undermines confidence in the fairness of these proceedings. The voluntary withdrawal of ASA Quinnen does not cure the prejudice. His misconduct has already tainted key proceedings, including the questioning of witnesses, and the remaining prosecutors either ratified or failed to intervene in his actions. So they're like, He stepped down. Who cares? You're all shady. You're never mind. I am. Don't come for me. We're going to get caught up. Hopefully by tomorrow night. We're going to watch some of it tonight. Hopefully tomorrow we get caught up. We're going to watch your favorite girl, Jen Macabre, tonight. Okay, so conclusion. Despite the prosecution's claim that they did not read any substantive material, the appearance of impropriety within the state attorney's office is profound in this matter. Without a filter protocol in place, the court cannot guarantee who else within the state attorney's office had access to the privileged communications, necessitating the disqualification of the entire office. That is crazy. The whole office. Bye. Gotta replace you. I'm like, wow. They're really requesting that. As previously stated, disqualification is a prophylactic remedy for likely future prejudice. The actions of the state attorney's office have cast doubt on the integrity of the entire case. A criminal defendant is entitled to at least basic level of confidence that the prosecution will proceed fairly and honestly. That confidence has been eroded here. The prosecution's misconduct in this case has been validated by the court's ruling, raising the question of whether further misconduct exists. Consequently, Courtney is now burdened with the need to scrutinize every action of the prosecution, fearing continued improper conduct. This is precisely the type of prejudice that disqualification is intended to prevent. The voluntary withdrawal of ASA Khalil Quinnan does not and cannot remedy the prejudice that already caused. The remaining prosecutors, having ratified and defended the privileged breaches, cannot be permitted to continue. Given the pervasive taint caused by both the direct misconduct and the supervisory failures, disqualification of the state attorney's office as a whole, or at a minimum, the disqualification of the remaining prosecutors assigned to this case, is necessary to preserve Courtney Clenney's right to a fair and impartial trial and maintain the integrity of the judicial process. Prado Firm, certificate, April 30th, 2025. Exhibit A. Oh, we're seeing the email. What is this? No. State of Florida's position of attorney-client work product communications. Oh, wait, we're going to read this. Oh, it's basically there. Please be advised that undersigned counsel's demand that the state of Florida, their investigators, and their law enforcement partners were complicit in obtaining attorney-client and attorney work product communication. Return any and all materials immediately. All communications between Ms. Courtney Clenney, her attorneys Frank Prado and Sabrina Puglisi, and their staff and their investigators are privileged. Further, any and all communications between Kim Clenney, Deborah Clenney, and their attorneys Frank Prado, Sabrina Puglisi, and their staff and investigators are privileged. Demand is made for the state to return all materials to undersigned counsel immediately. Through improperly obtained iCloud warrants, investigators that were assisted by the state obtained extensive communications between all parties referenced above. All the parties have been represented by this firm since 2022 in connection with providing legal advice, legal services, etc. Communications were made with the exception of privacy and privilege between clients, attorneys, and their attorney staff and their investigators and or third parties that were necessary in furtherance of the rendition of legal services. The state and their investigators did not use a taint team or a filter team after serving the overbroad and not properly limited in scope and time iCloud warrants. It is clear that the state and their investigators reviewed privileged communications as they have released portions to the media and use these protected communications in subsequent warrants. These communications are protected by the attorney-client and attorney work product privilege. The state clearly had knowledge that they were reviewing protected material. Should the state not provide all these material and communications to counsel, demand is hereby made that all materials be sealed and provided to the court until such time that evidentiary hearings are held on the violations of these privileges. The state should cease and desist its review of the communications between the above clients and their attorneys and attorney staff and their investigators. Finally, undersigned counsels demand that the Office of the State Attorney 11th Judicial Circuit recuse itself in this matter. Exhibit B is another second request. Oh, wow. So they were like demanding the material. Exhibit C. Third request. That's intense. And that's the end of the document. Wow. I'm shook. I don't know what is going to happen with this case. You scrolled out of this slide. Hey, Britt Nicole, good to see you. I can't wait for Courtney Clenney's trial. Who knows if it's even going to happen in 2025. She's probably going to be let out on bond, so we're not going to get anything until 2026. And by then, who knows? Who knows? I will be covering this case later this week. I also have, what I'm going to be doing this week is we're going to do a true crime. Well, we do all true crime, but we're going to do not Karen Reed related earlier like we did today, and then jump into Karen Reed later at night. So we do Millie After Darks over there covering the trial. I hope you guys can join. Thank you for being here. We're going to stay updated on the Courtney Clenney case. I'm on it. We're going to cover hopefully the ASA deposition if I can get my hands on it. So hopefully this week. And then we have Idaho 4 case tomorrow, a couple other cases, and Karen Reed. So I appreciate you guys for being here and hanging around. And be patient with me. I've been busy working and lifing outside of YouTube. So we can talk about that on another live. But I appreciate you guys for being here. Make sure you hit the like button. I will see you guys on the next live, Karen Reed. And yeah, I appreciate you for being here. I'll see you on the next one. Bye.
Thank you.